My name is Sriprapha Petcharamesree. I'm a senior researcher at the Faculty of Law at Chulalongkorn University. This module is about religious-based reservations to international human rights treaties and its implications to human rights in South Asia. So, as you can see from the title, the overall objective of this module is to examine the issue of religion-based reservations to international human rights treaties and the impacts of reservations on the enjoyment of human rights both in theory and practice with a focus on South Asia. I'll be focusing on 6 questions, namely, first, if reservations are permissible by law, and what criteria apply to reservations. Second, why do international human rights instruments attract more reservations than any other strands of international law? Third, why do states make reservations? Fourth, what constitutes religion-based reservations? Fifth, what is the behavior of ratification reservations of states in South Asia? And sixth, what are the impacts of reservations on enjoyments of rights and the fundamental freedoms in South Asia? And then I will conclude with a few final thoughts. The first question is if reservations are permissible by law, and what criteria apply to reservations. An international human rights instrument is a treaty under international law, which rests on the consensual nature of international law with the fundamental principle of state sovereignty. The state sovereignty is reflected in the law of treaties, which consent to be bound by a given treaty. When establishing on international plan their consent to be bound by a treaty, states are offered a possibility to the right to formulate reservations. Reservations are permissible under the Vienna Convention on Law of Treaties of 1969, or VCLT. The VCLT defines a reservation as any statement, however named, for example, reservation, declaration, or interpretative statement that aims to restrict either totally or partially the scope of application of a given treaty. As you can see from slide, it was made clear in Article 2D of the VCLT. And I just want to add that Section 2 of Article 19 of VCLT specifies that the state may, when signing, ratifying, accepting, approving, or acceding to a treaty, formulate a reservations unless, first, the reservation is prohibited by the treaty. Second, the treaty provides that only specified reservations which do not include the reservation in question may be made. Or C, in cases not falling under subparagraph A and B, the reservation is incompatible with the object and purpose of the treaty. While the VCLT makes 2 points clear in paragraph A and B, where reservations are not permissible, C is subject to different interpretations. So why do international human rights instruments attract more reservations than any other strands of international laws? Neumeyer, in his study, explained that reservations, understandings, and declarations to international human rights treaties are more common than for any other areas of international lawmaking. He offers certain reasons for this practice, and you can see from the slide in detail. But just to say that due to non-specific manner of language use, no reciprocity concept apply, and the aspiration natures in and of the international human rights treaties, many reservations were made by state parties. Then why do states make reservations? There are various reasons when states make reservations to some particular treaties, including human rights instruments. You can see from slide that some states might reserve because they have a sincere desire to comply with the treaty but face significant capacity constraints in implementing it. Second, some states may reserve due to a desire to avoid large portions of treaties in the event of conflicts. And third, certain states put aspects of their domestic legal order above international obligations. There is no explicit requirement for a state to provide reasons for the reservations. But in practice, the reason may vary from international politics, domestic politics, cultural and economic interests, to no desire or plausibility for them to change their domestic legislations or accommodate their local situations with the normative framework provided by the obligations and standards imposed by the relevant convention. As I mentioned at the very beginning, that the focus of this module is on religion-based reservations. So this question is about what constitutes religion-based reservations. The Universal Rights Group, or URG, established 4 elements. What constitute religion-based reservations? As you can see from slide 5, the reservation explicitly refers to a religion either as a standalone normative order or as part of the constitution or domestic law. The second one, the reservation is based on domestic law or constitutional law without explicit reference to religion, but religion is explicitly the main source of legislation. Third, the reservation is based on domestic law without direct reference to religion, but there is a strong presumption beyond reasonable doubt that religion is implicitly the main source of legislation. And the last one, the reservation is based on customs or religions, but there is a reasonable connection between custom and religions and the religions practiced in those states. Interestingly, the religion-based reservation is quite common. What is behavior of ratification reservations of states in Southeast Asia? Before looking at the reservations behavior of countries in Southeast Asia, I would like to point out how reservations look like at a global level. The 2 reports produced by Universal Rights Group in 2017 and another in 2019 mapped out the religion-based reservations of state parties to international human rights treaties. As you can see from slide, CEDAW attracts the largest number of reservations followed by CRC and then the ICCPR. Again, in terms of percentage, CEDAW has the largest percentage of religion-based reservations, followed by CRC and the CRPD. Interestingly, only 10% of reservations went to ICCPR are religion-based influence, while the ICERD has the smallest percentage of reservation. It is also interesting to see that they are very rare for treaties other than women's and children's conventions, and even then most reservations are specific. In Southeast Asia, ratification of international human rights treaties vary from one country to another, as you can see from the slide. What is seen from the slide shows that Cambodia has the highest number of ratification accessions, followed by Indonesia and the Philippines. Second, 3 international human rights treaties, namely CEDAW, CRC, and CRPD, were ratified by all ASEAN member states. Timor-Leste has yet to ratify CRPD. And then, when assessing reservations, Southeast Asian countries seem to follow the global trends. CEDAW has the largest number of reservations. To demonstrate religion-based reservations in the region, I pick up CEDAW and CRC to demonstrate how some countries explain their reservations. As you can see from the slide, reservation to CEDAW focus on two articles, namely Article 9 and Article 16. Two countries, Brunei and Malaysia, where majority of population profess Islam, tend to make reservations based on religions and beliefs, while Singapore indicates the multi-racial and multi-religious society and the need to respect the freedom of minorities to practice their religions and personal law, so reserve the right not to apply the provisions of Article 2 and 16, where compliance with the provisions would be contrary to their religion and personal laws. However, the said explanation cannot apply to Indonesia, the biggest Muslim country in the world, as its reservation is related to Article 29, which deals with dispute between two or more state parties concerning the interpretation or application of the convention. This is also the case of Myanmar, Thailand, and Vietnam. Another confirmation of the global trends regarding religious-based reservation is exemplified by reservations and declarations made to the CRC. As you can see from the slide, Article 14 attracts the highest number of reservations. Like the reservation made to CEDAW, Brunei, Indonesia, Malaysia, and Singapore express their reservations on provision of CRC that may be contrary to the Constitution and to the belief and principle of Islam. Now, what are the impacts of reservations on the enjoyment of rights and fundamental freedoms in South Asia? As already mentioned, all South Asian countries have ratified three common human rights conventions, namely CEDAW, CRC, and CRPD. Of all major international human rights treaties, as we already seen, CEDAW records the highest number of reservations, and South Asia makes no exception. Saraswati stated in her study that reservations have a substantial undesirable impact on the enjoyment of human rights. When a state does not fully subject itself to a human rights treaty, then that state may not take the obligatory steps to fully promote, respect, and protect the rights concerned at the domestic level. As you can see from the slide, there are several impacts with serious underpinning. These include, for example, the issue of citizenship. In Brunei and Malaysia, mothers are barred from transferring her citizenship to the children. The second serious impact is on marriage and family relations. As already pointed out, Singapore, Malaysia, and Thailand made another substantial reservation to Article 16 of CEDAW. And this article deals with equality in marriage and family relations and specific the rights that you can see from the slide. What I want to point out here is actually the Article 16, paragraph 2, emphasized on the abolition of child marriage, setting minimum age for marriage, and registration of marriage. Both Singapore and Thailand have reserved this article fully, while Malaysia has reserved Article 16, 1A, 1C, 1F, and 1G. The reservations to Article 16 are serious, as I said, because it is based on two main principles, namely equal rights to enter marriage and equal rights to choose the spouse for marriage. Both intend to protect women and children from forced marriage. Other general impacts have been reported widely. The previous UN Special Rapporteur on Freedom of Religion and Belief, Ahmed Shahid, issued a report in 2020. He stated that among states that have adopted such reservations, many also impose significant restrictions on freedom of religion and belief. and often discriminate against persons belonging to religious minorities, converts or apostates, and non-believers, as well as women, girls, and LGBT plus persons. In countries such as Brunei and Malaysia, criminalization of homosexual acts is frequently justified on grounds of religions and public morals, which are not well defined. And this leads to the multi-layered negative impact of gender discriminatory laws on access to health, housing, social security, education, and employment. I would like to add here that while reservations contribute to more and quicker ratification of human rights law that allow time for reserving states to gradually take steps to bring national laws and processes in practice to be in line with international standards. Often, reservations limit, either generally or partially, the scope of application of the treaty in domestic law. Finally, although reservation can be a useful political tool through which states can demonstrate their commitments to human rights, states only accept those obligations that they intend to fulfill. However, any blanket reservations that many states in Southeast Asia tend to make render monitoring or credible verification impossible. I would like to conclude this module by looking into tensions between religion-based reservations and aspiration for universality of rights. From what was demonstrated earlier, we realize that by far, states make decisions to enter reservation is influenced by religion base, which amount for over 40% of all reservations to core international human rights treaties. The URT report demonstrates that treaties, as I mentioned, CEDAW, CRC, and CRPD, that penetrate more squarely into societal issues and all private sphere have attracted most religion-based reservations. From various studies, practice of reservations to international human rights treaties show that states want to maintain general reservations, especially ones related to cultural and religious justifications. This is puzzling as state parties voluntarily ratify or accede international human rights treaties, while many of them making sure that they can avoid their obligations. Finally, reservations are manifestations of sensitive relationships between universal norms and national and local culture, religious beliefs, and tradition. The ongoing debates over universality of human rights and fundamental freedoms and national, regional, political, social, cultural particularities, which were brought to heated discussions in 1993, are one of the reflections of the interlink between state sovereignty and the universality of human rights, renders any reservation either unnecessary or obsolete.